had quashed the 2018 notification, and before the Honorable Supreme Court, this court took cognizance of it. There is a transfer petition because there was a writ which has been stayed by this Honorable Court. Notice has been issued, but the transfer hasn't been allowed till now. Now, Your Lordship, if I may crystallize the point of contention, Your Lordship, Devesh Sharma, as per the petitioners, applies to those who are fresh appointees and not applicable to those who are already in service. And they have relied upon the recognition order of 22nd September 2017 to state that this qualifies them, and this is separate and in addition to the 2018 notification. Another contention of theirs is that the 2017 recognition order was not challenged, and that is still in vogue, and on the strength of this, for perpetuity, they can, on the basis of the bridge course and the bachelors of education, be eligible for appointment. Now, Your Lordship, the source on the basis of which these minimum qualifications have been prescribed is only one, which is Section 23 of the Right to Education Act. Now, Lordship, just to refresh, Your Lordship, if I may just take you through 23 subclause 1, Your Lordship, of the Right to Education Act.
Like RT Act, Right to Education Act. Yes.
Heading is Qualifications for Appointment and Terms and Conditions of Service of Teachers. Subclause 1. Any person possessing such minimum qualifications as laid down by an academic authority authorized by the central government by notification shall be eligible for appointment as a teacher. Now, Your Lordship, I'll come back to Section 23. Now, please see 2010, 2011, and 2008 notifications. This will be, Your Lordship, if Your Lordship...
There were the compilations given by them.
Convenience compilation. I will refer to that only.
Brief note, convenience compilation. You want us to see what?
Lordship, I'll take you through the...
By the petitioner, yes.
Please, Your Lordship. Page 119 of that is the first regulation of National Council for Teacher Education.
NCT.
119. Please, Your Lordship.
All right.
And needless to say, NCT was appointed as the authority for prescribing academic qualification. I have that notification as well, if Your Lordship wants to see.
119, in which of the compilations you are telling us? Joint convenience compilation.
Joint convenience.
Joint convenience compilation.
Joint convenience. I apologize, Your Lordship.
ये वाला? इसमें भी 119 पर नहीं है.
119 पर नहीं है?
नहीं.
119 is a judgment.
He's referring to the first joint convenience compilation.
Joint convenience on behalf of the
volume.
This is what's volume 2. इसके और volume हैं. देखिए joint convenience compilation लिखे हुए.
Volume 3, volume 1 of that is.
Volume 1, page 119 of the joint convenience compilation by the petitioners.
देखिए यहाँ पे नीचे लिखा हुआ है joint convenience compilation 1, volume 1. वो दीजिए. उसमें हमारा नोट बना
just two lines of every notification I'd like.
Yes, sure.
Lordship, 23rd August 2010, in exercise of the powers conferred by subsection 1 of section 23 of the right of children.
Yes.
The short point is, Lordship, in the beginning, the preamble, so to speak,
that these are under section 23.
Section 23, subclause 1 of right to education, all three. Now, Your Lordship, may please come to the recognition order.
Yes.
and that will be, Your Lordship, with respect to Bachelors of Education, page
Yes.
129.
126, 129, yes.
129, 126 is Diploma in Elementary Education. Now, just please come to page 130.
Yes.
Now, therefore, in exercise of the powers vested under Section 14, Subclause 3A, 15, Subclause 3A of the NCTE Act, the National Northern Regional Committee grants recognition to a particular institute, which is National Institute of Open Schooling,
NIOS.
to conduct a bridge course. Those qualifications were under Section 23, Subclause 1, Your Lordship. Now, just before I proceed forward, I would like to just state what was the reason for this recognition order, Your Lordship. In 2010 and 2011 regulations, Your Lordship, if I may just bother Your Lordship to page 121 of the Joint Compilation, Volume 1.
Yes, we have.
Training to be undergone with BA, BSc marks and B.Ed qualification shall also be eligible for appointment up to 1st January 2012, provided he undergoes after appointment an NCTE recognized 6-month special program in elementary education. Now, Your Lordship, there was no time frame prescribed to get this element, to get this minimum qualification. Right, Your Lordship? Now, please come again to the Right to Education Act, which is why I said, please, I'll bring your attention again to the Right to Education Act, Your Lordship. Section 23. There's a proviso to subclause 2, the second proviso, provided further that every teacher appointed or in position as on 31st March 2015, so before that, who does not possess minimum qualifications as laid down under subsection 1, shall acquire such minimum qualifications within a period of 4 years from the date of commencement of right of children to free and compulsory education. It commenced from 2015, Your Lordship. So by 2019, 31st March 2019, those teachers, including the Bachelors of Education qualification,
They had to acquire the minimum qualification
acquire the
in terms
minimum
of the NCT norms.
and
Yes, all right.
Under 23(1).
23 subclause 2, they had to acquire the minimum qualification proviso to subsection 2 by 2019.
19.
Please, Your Lordship. Now, Your Lordship, in this regard, just please see one communication. This is again the Joint Convenience Compilation, page 168. This is by the HRD Ministry.
MHRD notification 12/8/2014.
Sir, this is 3rd August 2017, page 168, annexure C17 of the Joint Convenience Compilation. C17.
Yes.
Please. Dear Professor, this is regarding training of untrained. Dear Professor, this is regarding training of untrained in service.
Can I just tender my copy for convenience?
No, that's all right.
No, we'll have to mark in our copies. Yes, I got it.
Got it.
Page?
Page 168, annexure C17, Your Lordship.
ये भी नहीं
ये भी नहीं है.
ये एक कॉपी है सर जो आपने
All right.
Dear Professor, this is regarding training of untrained in-service elementary teachers in the government aided, unaided private school. It is apprised that the amendment to Section 23, Subclause 2 of the Right to Education Act to extend the period for such training to 31st March 2019 has been passed by the Parliament. A broad strategy to complete the training of all in-service untrained teachers by 31st March has been devised by MHRD. It has been decided that NIOS will be overall in charge for conducting the online Diploma in Elementary Education program to a Swayam portal. And this will also include the Bachelor's in Education. Now, Your Lordship.
Yes.
NIOS has been asked to be the primary center for doing these bridge courses, and they had to be done in a very timely fashion because 2019 was the cutoff date for all. This was only pertaining to those who were appointed prior to 2015. So NIOS made a proposal to NCTE along with a direction under section 29 of the NCTE Act, which says central government may override in some regards, to the NCTE to consider this. And the reason why, if your lordship now please see the recognition order.
Yes.
22nd September 2017, page 129.
Yes.
हमने एक्चुअली उस दिन इसी से देखा था, ये तो था नहीं.
Second recital, sir, directly. And whereas the NCTE has received directions under section 29 of the NCTE Act from the Ministry of Human Resource Department, the project proposal for recognition of 6-month PD PPET ODL online distance learning program through ODL mode has been submitted by NIOS because of the constraints of time and the sheer number of teachers who hadn't completed the minimum qualification. These relaxations were sought to conduct this to ODL. And whereas in view of the above mentioned direction of MHRD, NCTE states that even the executive committee has considered the proposal because NCTE is not a spokesperson of the ministry. So they have done their independent decision making as well. Now, whereas having second last recital, whereas on page 130, whereas after having considered all the above facts and figures, the NRC considered the case in its 275th, decided a recognition be granted to National Institute of Open Schooling for 6-month PD PET ODL program through Swayam portal for training of in-service untrained teachers under section 14 of NCTE Act, and I'll come to the NCTE Act as well. Under section 14 of the NCTE and clause 7, subclause 16 of NCTE regulations. These regulations, your lordship, are NCTE recognition and norms standard of institutions act, regulation 2014. Now, therefore, in exercise of the powers vested under section 14.3a, 15.3a of NCTE Act, the Northern Regional Committee hereby grants recognition to National Institute of Open Schooling. Now, your lordship, just to sum up, I will just take you through the provisions which are very important and which will bring to light the difference, how they cannot be equated and how different powers are being exercised. This will be the National Council for Teacher Education Act. I have extra copies if your lordship.
NCTE Act. The whole problem is the compilations are
Compilations. We are not able to.
compilations.
We hands on the correct one.
There was another compilation given by Ms. Divedi also.
The Mamta part.
Huh?
Your lordship, I have extra copies of the NCTE Act.
Please pass it. We have Mandeep Kalraj, yours convenience compilation and joint compilation and whatever you have filed, 3, 4, 5, 6 of them.
Yes, here is sir. इसमें है.
ये वाला
NCTE recognition
index वाला
NCTE Act.
index वाला एक folder.
Index वाला दीजिए ये वाला. 28 to 43. हमने उस दिन इसी से देखा.
हाँ, हम लोग ने section.
Lordship, please first see section 12A
Yes.
of the NCTE Act. Power of council to determine minimum standards of education of school teachers. Minimum standards of education of school teachers. For the purposes of maintaining standards of education in schools, the council may, by regulation, determine the qualifications of persons for being recruited as teachers in any pre-primary, primary, upper primary, secondary.
RTE Act you have passed on. Where is the NCT Act?
I'm so sorry about it.
NCT Act ले लीजिए उनसे. है आप आपको तो निशान लगा हुआ है.
I am deeply sorry. 12A, sir. Power of council to determine minimum standards of education of school teachers. For the purpose of maintaining standards of education in schools, the council may, by regulation, determine the qualification of persons for being recruited as teachers in any pre-primary, primary, upper primary, senior secondary school, etc. Now, Lordship, Section 23 stated that the minimum qualifications will be set by an academic authority as so notified by the central government. This is the NCT authority, NCT. NCT derives its purpose, its power to determine the minimum qualifications from Section 12A. Now, Your Lordship, please come to Section 14, which is the section referred to in the recognition order. Recognition. And please see the chapter, recognition of teacher educational institutions. Not about prescribing minimum qualification, Your Lordship. Now, please come directly, sir. 14, recognition of institutions offering courses of training in teacher. Every
3A.
14.3A. On receipt of an application by the regional committee from any institution, which is NIOS, under subsection 1, and after obtaining from the institution concerned such other particular as it may consider necessary, it shall, if it is satisfied that such institution has adequate financial resources, accommodation, library, qualified staff, laboratory, and that it fulfills such other conditions required for proper function of institution for a course or training in teacher education as may be determined by regulations, pass an order granting recognition to such institution subject to such conditions and may be determined by regulations. This is for recognition of an institution. Now, please come to 15 because it said 14.3A and 15.3A.
Yes.
15.3A deals with for recognition of a new course by an already recognized institution. So, NIOS was applying for both. It was applying for recognition as an institution
and as well as for running the quiz course.
PGPE through online distance learning.
PDPET, yes.
Yeah, PDPET. 15. Permission for a new course or training by recognized institution. Where any recognized institution intends to start any new course or training in teacher education.
3A itself.
Please, Your Lordship. 3A.
On receipt of an application from an institution under subsection 1.
And after obtaining
recognized institution such other particulars may be considered necessary, the regional committee shall, if it is satisfied,
that such recognized institution
a new course may be recognized, yes.
Has such adequate as may be to pass an order granting permission subject to such conditions as may be determined by regulation. So the recognition order has done only this. It has recognized NIOS to provide
as an institution to deliver the courses.
First as an institution,
online distance learning.
First as an institution and then as this additional course.
As an additional course. It is not prescribing qualification. The qualification power is under section 12A, which hasn't even been referred to in the order, recognition order at all. And as I stated, Your Lordship, all the regulation prescribing the minimum qualification derived as source explicitly from section 23 subclause 1 of Right to Education Act. Lordship, what is the effect of this recognition order is also, as I stated, this is with respect to persons who did their B.Ed and were appointed before 2012, January 2012, but did not complete the minimum qualification. And then Right to Education Act comes along and they said, okay, sir, you have to finish your bridge course within 2 years. That was further extended till 2019. Then the government, recognizing the sheer number of persons who had not completed, essentially,
and the unavailability of the institutions.
Unavailability of institution as well as the mode, physical mode wasn't possible, said NIOS, why don't you apply to NCTE? We are going to pass an order under section 29 as well. So NCTE relaxes its conditions, Your Lordship, under National Council for Teacher Education Recognition Norms and Procedure Regulations 2014. And it has granted recognition under these regulations. not the minimum qualification regulations, Your Lordship. And these regulations, Your Lordship, of which also I have a
Recognition is
copy,
for offering which course?
Bridge course.
bridge
Which
code.
course and to whom?
NIOS.
To those who were appointed before 2015,
15.
as per the Right to Education Act, Your
Yes,
Lordship.
all right.
Now, at best, what this has done, Your Lordship, has not relaxed even out of service. If they apply again, then they have to meet the new minimum qualification. To that extent, it is prospective for sure. It is about those who are carrying on already, be it in government school, be it in private school, just so that overnight there is no vacancy, overnight there is no
Otherwise, they'll all be thrown out. Yes.
Otherwise,
Existing services have been saved.
existing service member, but that does not mean in perpetuity if they keep
A fresh
applying.
process is started and they get to do it on basis of this.
Yes, on this recognition
bridge
order, Your
code, it would
Lordship.
not
Please, Your
happen.
Lordship. And as far as Rajasthan is concerned, now there are no, as I stated, Lordship, there are no averments about them being in service, but
Rajasthan का तुमने argument भी नहीं सुना. It is addressed on behalf of Rajasthan here.
I did from the chart to say that
From the chart, no, this is a transfer petition.
yes, Your Lordship.
Transfer petition, so the petitioners are not here.
the petitioners are here. I am representing.
You are representing the Rajasthan petitioners.
Rajasthan petitioners are here. They are identically placed. It may not be correct to say that they're not. I'll establish.
So they have put their PD-PET certificate on record. So we'll assume that they're in service. Let assume there is no the staff selection board. They were served, but they're not here. So that information is not with the Rajasthan government per se. However, even then, that is why it became important for me to address this. That even if they were in service, it does not mean that under the 2022 advertisement,
They become eligible.
they become eligible. And the 2022 advertisement, again, because it was done after the Rajasthan quashed it and it came to Supreme Court, it is not on the same level as those who had been appointed.
Right. Thank you.
Obliged.
Yes. What do you want to say, Andrew?
Just 2 minutes. The interveners, I may be heard for 5 to 10 minutes, my lords. I will not repeat any of the points that have already been made, my lords.
My lords, I was for the state of Himachal, my lords, just 2 minutes of submissions.
I heard you.
Yes, my lords, but on the last occasion, your lordships were ending the arguments on this side, my lords. I just wanted to point out 1 or 2 more things, my lords.
What?
Basically, so of course, now my friend has argued on the provisions, my lords. That is something.
You had
which I
also
pointed
argued
out.
on provision, and there was another council who was also addressing.
Yes, I was only addressing.
And
Just one.
Mr.
just one
Atre
point.
argued for the state of Uttarakhand.
I just want to point out one thing.
And Mr. Punjab, Mr.
Punjab is also here.
Vivek Jain. Yes.
My lords, I won't take more time. I was heard for
We
some
did not
time.
indicate any
Express
intention.
any intention at all. Huh?
Acha, all right.
Now, my lords, the recognition order, as I had submitted earlier also, cannot grant eligibility. That can only be an exercise under 23(1).
Correct.
I had submitted that. My
You
friend from
submitted
Rajasthan is
that
also.
your
Yes.
friend today repeated
Now,
Rajasthan only.
Now, my lords, now page 119, the 23/8/2010 notification. My lords, my simple point is, if 28/6/18 has gone because of Devesh Sharma, now we have reverted to the 23/8/10 position as amended with 29/7/2011. Now, under this notification, my lords, there is obviously no eligibility for B.Ed qualified people, except that the para 2, my lords, which says that para 3, I'm sorry, which gives them the eligibility up to 1st January 2012. Now, your lordship had asked me last time if in Himachal there was an extension of this. There was none. So after 2012, my lords, there is no right saved for any B.Ed qualified person to have any to appear in any recruitment. I'm sorry, Lord.
On
Yes.
basis of any bridge course, etc. Subsequently.
Yes.
done.
So of course the bridge course now, because there was no requirement for them to do it in 6 months, 2 months, whatever at the time. So this kept on happening. These people kept on taking bridge courses. Now, therefore, under 23/8/2010, once this 2012 deadline goes, after that, B.Ed qualified people in whatever form, maybe in service, maybe out of whatever it may be, do not have a right against fresh appointments.
Yes.
Now,
They are not qualified. They are not holding the requisite qualifications so as to apply in fresh notification.
exactly. Now, Mlaws, your lordship has asked me why the earlier the course of action which was taken in Vishwanath, etc., Jaiveer, etc. And on that, Mlaws, I'm only reminding that there was never a finding that DL-Ed of 18 months and 20 months are fundamentally opposed to the pedagogy which has to be adopted for classes 1 to 5. This court in Devesh Sharma laws has given a very strong finding that B.Ed people are not suitable at all. You can add to them whatever, but they are not suitable at all. And therefore, Milos, that course should not be adopted. One small point, Milos. I think so of course the other side had pointed out the Devesh Sharma order, the MA order of 8424. But there's another judgment after this which came called Naveen Kumar Milos. I'll just hand that out, which was dealing with a notification which had come up in the interim after Devesh Sharma, a notification and recruitment which had taken place, and Naveen Kumar, the bench has held Milos that any notification which gives B.Ed people the right to come into service for primary cannot be sustained. Now, Milos, therefore, reading all of these three together, I'm just handing this out, Milos, only for the sake of completion because your lordship will be now dealing with the law on this. Your lordship may just see this. Yes, please. Please have para 5. So, Milos, admittedly, in the present case, the appointment orders in favor of B.Ed candidates were issued in September 23. That is after the date of our judgment in Devesh Sharma, which was delivered on 11/8/23. And they go into the MA order, and in 12, para 12. So this, according to the court, was already clarified in the MA order. In fact, so just above para 12 also, the aforesaid provision placing B.Ed as a qualification is again subsequent to the notification of 28/6/18, which has already been quashed and set aside by our judgment in Devesh Sharma. Therefore, by implication, qualification given in the Chhattisgarh rules to the extent it makes B.Ed a qualification also cannot be implemented following the law in Devesh Sharma. In fact, we have been shown today an order of NCT dated 4/9/23, whereby the judgment in Devesh Sharma was communicated to chief secretaries. In spite of this, appointments were given to B.Ed candidates, which was illegal and has thus rightly been quashed.
Pure B.Ed. It doesn't
Yes, Milord.
refer to any bridge course.
B.Ed plus B.Ed subject to a bridge course after appointment. So B.Ed plus bridge course was certainly within contemplation. The only distinction was they were not in service. This has not been dealt with specifically.
These are not in service candidates.
Now, Milos, on that, Milos, just one small point. In service candidates with the state are in a different position. In service candidates who are claiming a right through private appointment. Now, Milos, please remember, after 2012, these appointments should not have been made in any case. Now, after 2012, if now somebody is claiming a right because of their private service, Milos, how is that fair?
All right.
That's all, Milos. Very good.
Yes.
Maloj, I am for some of the interveners. I may be heard only for 5 minutes, Maloj. I will not take more than 5 minutes.
What do you want to say?
Maloj, I have something to say.
You are appearing for?
Maloj, I am for the.
Both of you are together?
No, Maloj, I am. Maloj, I have something to say that the state has not said so far. I appear for
You
some
are
of the
for
interveners.
which
Maloj,
category of
Maloj,
candidates?
I am qualified DL-Ed with TET. We are placed.
You are
high up in
opposing their case?
Yes, Maloj, we are opposing Maloj. Maloj, may kindly hear me. Maloj, may see the Maloj, may kindly have my compilation first.
Oh, baapre.
I'm so sorry, Maloj. Maloj have already indicated there are too many compilations. Maloj, much has been made.
We have to ask someone to compile the compilations.
Maloj, much has been made of the order that was passed in review in Vishwanath. But in my respectful submission, Maloj, Vishwanath, the order in review.
No.
Maloj, I'm sorry.
What's your name?
Maloj, Sarthak Raizada.
Sarthak.
Raizada.
Raizada.
Maloj, much has been made of that order, but Maloj, in my respectful submission, what the order in review really does is this. It completely upsets the judgment that was passed in the main petition. And why do I say this? Maloj, may kindly have the order in review first. It's at page 382, Maloj.
382?
Yes, Maloj. That's the order in review, Maloj. And then I will show to Maloj who were the petitioners who were before the High Court. Because essentially the relief that has been granted to the review petitioners are the same who were before the High Court whose writ petition was dismissed in the main petition, Maloj. And therefore, the order that has been passed in review may have attained finality, Maloj. But it is only binding inter se between the parties. and your lordship will have to go back to Jaivir Singh to see what the law really laid down was.
It doesn't lay down any ratio descendai.
Yes, my lords, it's not. It's a direction. My lords, may kindly see paragraph 3, my lords. The review petition is in para 2, my lords.
Yes, sir, page
Page
382.
382, my lords.
Yes.
Vishwanath wala review.
My lords, may kindly have para 2 first. We have already clarified in the judgment under review that one-time scheme was provided solely to safeguard the interest of those teachers who were employed as on 10th of August 2017. This is the cutoff date for the RT Amendment Act, my lords, of 2017. We are therefore not inclined to entertain the present review petitions as well as miscellaneous applications. However, to avoid any confusion, we again clarify that the 18-month diploma obtained by such persons who were in employment as on 10th of August 2017 and who have completed the diploma course of 18 months would be treated as valid diploma holders for the purposes of applying in other institutions. So much has been made of these other institutions or for promotional avenues. Now, my lords may see that the order that the High Court had passed in Jaivir Singh, because it shows who were the petitioners before the court. My lords, that
This
order.
is a review arising from Jaivir Singh.
Yes, my lord, this is a review that is arising from Jaivir Singh. Now, my lords, may kindly have page 312.
From Jaivir Singh or Vishwanath?
My lords,
Vishwanath is a part of Jaivir.
Jaivir only.
Vishwanath is part of Jaivir Singh. It's the review in Jaivir Singh, my lords. It clarifies Jaivir Singh.
Yes,
Now,
312.
yes, my lords.
List,
my lords, may I have
list of
page-
petitioners before the High Court.
Yes, my lords, may kindly have that. My lords may have page 318, para 3.
Hmm.
Lords have
Para
it?
3.
Yes.
My lords, may I read? The case of the petitioners is that they were initially appointed as assistant teachers in private unaided schools in different districts of the state of Uttarakhand. They were employed as assistant teachers during the period 2014 to 17. They state, this is very important, my lords, 2014 to 17. These were the petitioners, and their writ petition was eventually dismissed by this honorable court. They state that they have experience of teaching students of primary school from classes 1 to 5. The petitioners possess degree of graduation and they have cleared the teachers eligibility test. They have obtained diploma as recognized by NCTE in elementary education through ODL mode conducted in iOS. Now, my lords, may quickly have page number 332, para 14 and 15.
Yes.
15 actually, my lord. The petitioner are also amongst those in-service teachers who undertook the said DLED course for untrained in-service teachers through the ODL mode, and they have been awarded the diploma in DLED. So these were the petitioners, my lords. And ODL course was not done by anybody who was not in service. So the review petition essentially upsets its own judgment in the main petition, my lords.
They were the DLED. What do you want to say?
My lords, they have relied on that parity has been given to 18 months and
DLED,
24.
18 months and 6.
So the petitioners who were before the High Court in Jaivir Singh
Hmm.
were those who came in employment before 2017.
Yes.
They were teaching in private aided,
Between
unaided schools.
2014 to 17.
Yes, my lords.
Hmm.
In private unaided schools. They came in service before 2017, before the cutoff date, and their writ petition was dismissed, and they were seeking parity with 24 months DLED program.
DLED course, yes.
So the judgment, my lords, in review is essentially upsetting the entire. And my lord, there was an interesting development that took place. What happened was that the Patna High Court came out with a judgment in Sanjay Kumar Yadav, wherein the Patna High Court said that the teachers who are teaching in private schools, they may be allowed to apply for government institutions. They were also carrying that 18-month, or they had also completed the 18-month.
We are not even dealing with the 18 months already.
My lord, they have sought parity.
They have got-
They have sought parity,
understand.
which is why I'm
Parity.
explaining what happened, because Jaivir Singh perhaps is where the law is, my lords. So what happened in that case is that permitted the persons who had completed the 18-month course to compete to be considered for government recruitment in primary schools. This was the judgment of the Patna High Court, my lords. Now NCT, my lords, accepted that judgment. I have placed that letter, my lords, of the NCT. My lords may kindly have that letter. It's at page 337, my lords.
All right, then what happened?
My lords, NCT, may I just give some background of that, my lords, that
Why
letter?
are you going into
My
DLED?
lords, what happened was, on that same letter, in Jaivir Singh, NCT's letter accepting the judgment of the Patna High Court, saying that 18-month ODL program DLED is equivalent to 24 months. There is a finding in Jaivir Singh, even that letter was illegal. My
Read
lords,
that.
my lords, kindly have that.
This first the
Page
letter referred.
337, my lords.
Hmm.
No, my lords, not 337.
Not 337.
My lords, maybe. It's 230.
230.
Yes, my lords.
All right.
Lords, may kindly have page 229 also before the, because there are two letters of the NCT. I'll refer to.
229 onwards.
Yes, my lord, there are two letters of the NCT.
Hmm.
My lord, this is a letter of the NCT written to the government of Bihar, my lords. The first letter. Please refer to your letter number so and so on the above mentioned subject. It is brought to your notice that the NCT has decided to accept the verdict of the Honorable Patna High Court in the to so and so action. Now, my lords, may kindly have the next letter. This is the letter dated 6th of January 2021, and there is a specific finding in Javeer Singh on this particular letter, my lords. I am directed to refer to Ministry of Education letter wherein the following has been mentioned. The verdict of the Honorable High Court of Bihar, letter dated so and so, received from Uttarakhand NIOS DLED TET Teacher Association on the subject mentioned above. It has been requested that teachers of Uttarakhand who have completed DLED course from NIOS may be eligible to apply for new vacancies declared by the state in line with the state of Bihar. This was the letter, my lord, that was written by the state of Uttarakhand. It would be pertinent to mention here that the High Court of Bihar in so and so has ruled within its order dated that NIOS DLED cleared teachers working in government aided, private unaided schools shall be allowed to apply for appointment as elementary teachers training degree DLED be considered as recognized degree for the same. Now, my lords,
We'll continue tomorrow. We'll continue tomorrow.
कल तो कोई चैम्बर में नहीं रखा उसको.
You are
Supporting the case of the petitioners. All right.
petitioner side, you stand this side, why are you that side?
Pensioners matter, bank pensioners matter. 302 part.
Both tomorrow 3 p.m. But first पहले ये होगा उसके बाद बैंक वाला होगा. First we conclude this.
Yes.